If you're watching this, chances are you or someone you love is going through a really tough time after getting medical care. We're going to break down what can feel like a super complicated process, making a clinical negligence claim against NHS Scotland, and we're going to do it step by step.
It all starts with this one big question, right? Did something actually go wrong? You might be feeling confused, or maybe just a sense that the outcome you got wasn't what you were told to expect.
And look, while that path isn't always easy, it is a path. We're here to give you a kind of roadmap for the journey ahead, just so you can understand your options. So, let's dive in.
Here's our game plan. We'll walk through 6 key stages. First, we'll figure out what negligence even means in legal terms. Then, we'll talk about your first practical steps, how a case is actually built, what happens when you formally engage with NHS Scotland, some critical rules you absolutely need to know, and finally, what justice and compensation can look like.
So, let's start with the most important question of all. Was what happened truly negligence, or was it a really unfortunate outcome that wasn't actually anyone's fault?
Now, this right here is a crucial distinction to get your head around. Medicine isn't perfect. Sometimes treatments don't work. A bad result, on its own, doesn't automatically mean there was negligence. For it to be negligence, 2 things have to be true. First, the care you got had to fall below an accepted professional standard. And second, that failure in care has to be the thing that caused the harm. You have to prove both.
In Scotland, this is all measured against something called the Hunter v. Hanley standard. Okay, what does that mean? Well, think of it like this. You'd expect any qualified electrician to wire a plug safely, right? You don't need them to be a genius, just competent. It's the same idea here. The big question is, did the doctor or nurse act with the skill that an ordinary, competent professional in their specific field would have?
Okay, so what if you suspect that your care did fall below that standard? Let's talk about what you can actually do, your first practical steps.
This is so important to understand. There are 2 totally separate routes you can take, and they don't automatically connect. The NHS complaints process is designed for raising concerns, getting answers, maybe getting an apology. A legal claim, on the other hand, is a formal process specifically to get financial compensation. And let me just say it again, because this is key. Making a complaint does not start a legal claim. They are 2 different things.
So, if a legal claim is something you're considering, here's the bottom line. You need a specialist. This area of the law is incredibly tricky. You want a solicitor who lives and breathes Scottish clinical negligence cases, not just a general personal injury lawyer. That specific experience is absolutely crucial.
Right, so once you've got that specialist solicitor in your corner, the next big phase begins. And that's all about gathering the evidence that will become the bedrock of your entire case.
Building your case really comes down to 2 main pillars. First, your solicitor is going to get their hands on every single relevant medical record. And second, and this part is totally non-negotiable, those records are then sent to an independent medical expert. Their job is to review everything and give a professional opinion on the standard of care you received.
And when we say records, believe me, we mean everything. This goes way beyond your basic GP notes. We're talking detailed theater records, nursing notes, lab results, scans, even internal hospital incident reports. And sometimes what's missing from the records can be just as telling as what's actually there.
This quote pretty much says it all. That independent expert, they are the absolute foundation of the case. If they look at all the evidence and conclude that, in their professional opinion, the care was reasonable or that it didn't cause your harm, then realistically, the case can't go forward. Their opinion is that important.
So, let's say you do get that supportive expert evidence. What happens then? Well, this is where the game changes. You move into the formal process of engaging directly with NHS Scotland's legal team.
Now, you won't be dealing with the hospital itself. Your solicitor will be engaging with an agency called the Central Legal Office, or CLO. And it's important to know who you're up against. This is a highly experienced, very sophisticated legal team that defends all of the NHS health boards. They are absolute experts in this area.
So the process usually follows these key steps. Your solicitor will send a very detailed letter of claim. The CLO will then investigate and send a response, either admitting that negligence happened or denying it. If they deny it, the next move is to formally raise the case in court to keep the pressure on.
Okay, let's pause and cover some absolutely critical rules of the road, things you cannot afford to get wrong. We're talking about timelines and funding.
Remember this number, 3. In almost every case, you have just 3 years to start a formal legal claim. It is a very strict deadline, and that clock is ticking.
But there is a really important exception. It's called the date of knowledge rule. Basically, that 3-year clock doesn't always start on the day of the treatment itself. It starts from the moment you knew, or could have reasonably been expected to know, that the harm you suffered was actually linked to that earlier treatment. This is huge in cases where an injury doesn't become obvious for months or even years.
Now I know what a lot of people are thinking. How on earth could I afford to do this? It's a fair question. But in Scotland, these claims are usually handled on what's called a speculative fee basis, which is a type of no-win, no-fee agreement. It means that if your case doesn't succeed, you don't owe your solicitor any fees. It's a system designed to make justice accessible to everyone.
Which brings us to our final section. After everything we've talked about, what is the point of all this? What can a successful claim actually achieve for someone who's been harmed?
The entire goal of compensation is to try and put you back in the financial position you would have been in if the negligence had never happened. That includes an amount for your pain and suffering. That's called solatium. But it also covers all the real-world financial losses, wages you've lost and will lose in the future, medical bills, and crucially, the cost of any ongoing care you might need for the rest of your life.
Look, let's be totally clear. This is a demanding journey. It takes patience, it takes courage, and it takes strong evidence. But it is a system that works. For people who have genuinely been harmed by care that fell below the standard, it is a proven, rigorous, and fair way to get accountability.
And that leads us to the final question, the one that only you can really answer. Now that you understand the steps, the standards, and the stakes, is this path to accountability the right one for your situation? The answer always begins with knowing the road ahead.